Okay, well, I'm a little bit new to this environment and this platform, so you'll have to bear with me if I get a hiccup or two here, but I'm used to standing up in front of people and speaking like I think all of us are, but we've had to adjust, and here we are adjusting. Isn't that part of farming, having to adjust to the current circumstances and do the best that we can? So make sure I got everything up there. And I'll kind of just jump in here and I don't and Jesse and Thomas just interrupt me at any time if you have questions or if something's not working right. I'll just assume that it is and until we hear otherwise. But I've been through these small ruminant master programs. My wife and I have been through a couple of them. And as Thomas was saying, we own a goat farm here in actually in Overton County. I practice in Cookeville, but we live in Overton County. So I just want to kind of talk about the legal considerations of farming in Tennessee. So it'll be very specific to small ruminants, sheep and goats. I know goats much more than sheep, but I think it crosses over very well. And we're going to talk about the legal considerations of what we should be thinking about on the business side of raising these goats and sheep. So I will go forward here on my slides. There you go. Okay, well, I am a true attorney. I am here as a farmer, but I guess I always have to remember my roots as an attorney. So I'll begin with a legal disclaimer, wouldn't you figure, right? I always hate to start off this way, but it's necessary. I'm a licensed attorney in the state of Tennessee. On these slides and this video, and usually when I'm speaking in person, I always want to make sure people understand that I'm giving very generic advice, very general advice that I think is specific to our situation, but it's not legal advice. Legal advice is something you get from an attorney when you're talking with them one-on-one about your specific situation. So I just want to make sure that when we start off today, we're going to be talking about laws, we're going to be talking about liability, we're going to be talking about circumstances, but they're not your circumstance. And because of that, we don't have a legal relationship, you and I. So I'm not speaking as your attorney, giving you very specific legal advice. I always put down here, you would know if that were the case because I would begin charging some kind of exorbitant amount of money. But that's lawyer humor. Okay, so with that being said, we'll go ahead and get on the way. In the law, one thing that's important for us to know is when you have somebody speaking to you, you kind of want to understand why is what they're saying important. So as Thomas said, I'm an attorney. I'm a licensed attorney in the state of Tennessee. I'm a graduate of Belmont School of Law. I'm a former prosecutor for the state of Tennessee, and I'm currently have a private practice in Cookeville. So I'm an attorney. But more importantly for our conversations today, I'm a farmer. I'm a goat farmer. My wife, Donna, and I, we operate Tennessee Kiko Farm. We have about 100 registered Kiko goats, and that's what we do. We stay very busy on the farm. It at times consumes our lives, as it does with yours, and we want to make sure that we're doing the very best thing for our animals and for the people that come onto our farm. So that kind of brings us today. And I probably should say as well, before we get started into it, you'll have to forgive my voice a little bit here. Like many of you, I spent the entire weekend cutting, rolling, moving hay, and the seasonal allergies have gotten me crazy. So I'll drink my cup of water and tea as I go through this and try to, so if I cough a little bit, it's just the hay that we've been moving so much of. I think a lot of you can probably agree with that. So the common topics, and again, normally I rely on, kind of audience feedback of what's important to you. I think we'll get a little bit of that, but I've talked with enough groups of people about this that I can tell you that some common topics that often come up are liabilities when people come to my farm. That's the first topic we'll discuss tonight. Things like agritourism, when people come to your farm to buy animals, what kind of liability, or is there any liability for somebody who comes onto your personal property in the form of your farm? Do I, as the farmer, have some kind of liability if something were to happen, if they were to be injured? And we'll talk about that in some depth, and we have some scenarios to go through. The second topic that I get a lot of questions about, people want to know about their animals, whether or not they're liable if their animals do something. So I have large guardian dogs. A lot of you probably do as well. If my dogs bite somebody, what's my liability? If my sheep or goats, get loose and cause property damage, do I have some civil or criminal liability in that circumstance? So we'll talk about that as well. And then the third area that I planned on talking about, although I'll take some guidance, are contract agreements, verbal versus written agreements, land lease agreements, things of that nature that sometimes we come into. There are other topics that come up quite often, you know, business formations and such. Sometimes there's topics that come up when people are interested in selling products off of their farms. Those obviously also have some legal implications, but these are the three main areas I figured we would go over tonight. So let's begin at the beginning, I guess. How does the law define agriculture? Because we're going to talk here about very specific laws, and one of the first things we have to do is be able to understand what is it that we're talking about. Agriculture can be a very broad term, or it can be very specific. You know, are we talking about crops? Are we talking about livestock? Are we talking about, you know, other activities that just naturally go along with growing of crops and growing of animals? So in the state of Tennessee, when we're talking about laws, there's a legal definition. There's a legal definition for pretty much everything in the state of Tennessee. So what I put up here is the actual statute. And it's a lot of words, but it's important for us to kind of understand that agriculture means a lot of things. It can be the land and the buildings and the machinery. It can be the farm stock, the animals. It can be commercial products, nursery stock. It can be recreational and educational activities. So all of those things, as far as the state of Tennessee is concerned, is agriculture. So again, you could talk about a hay maze. You could talk about when the 4-H club comes out to your farm to see your animals. Those are all under the term of agriculture in Tennessee. So when we talk about agriculture, those activities are included in that. In the state of Tennessee, we live in we're blessed to live in a great state. I don't know if, I mean, maybe people want to disagree, but I think we live in a great state, and especially a great state for farming. Tennessee laws really support us as farmers. They support our right to be able to farm, and our laws benefit us very much. And that's probably a good point to mention that if you were to move to another state, some of the things that I'm talking about tonight won't apply to you. They won't apply in Kentucky. Maybe they don't apply in Alabama. They don't apply in New York. They, you know, don't apply, you know, in urban environments sometimes. So what we're talking about is very specific to Tennessee. But in Tennessee, we have an actual statutory right to farm. And so what that means is that we have certain presumptions given to us where other areas, they may have to prove these. It's presumed that, for example, that farming is not a nuisance in the state of Tennessee. You know, our animals making noise and having smells and having mud on the road and, you know, certain things of that nature, they might be considered a nuisance by some people, but the state of Tennessee, being very supportive of agriculture and farming, has established through Tennessee Code Annotated, and I have a couple of them listed here, that we have what's called a rebuttable presumption. That is, we start off from the point that farming is not a nuisance. So again, and we'll talk about other laws that benefit us that the state of Tennessee has enacted, but this is just a good place to start. When we talk about agriculture in Tennessee, we now know kind of what it is as far as the state's concerned, very broad definition, and the state gives us a lot of flexibility and leeway because, again, the state of Tennessee favors farmers. It is, again, a great state, I think, to raise animals and to farm in. So let's get into the nuts and bolts, and probably the most common topic that I get asked when people come onto my farm for various reasons. People may come onto my farm as visitors to visit the farm. They may come onto my farm in order to buy animals off of my farm. They may come onto my farm as uninvited guests. But in any way, when people come onto my farm, do I, as a farmer, have a liability and therefore some kind of legal liability and things that I need to be concerned about? So my topic here is visitors to my farm and the liabilities they bring with them. Kind of alluding to what I'm heading down to, that yes, they do bring certain liabilities with them. But it's not something that we should shy away from. And again, I hope that's the overarching topic that we have here as I'm talking. These laws and these liabilities shouldn't really discourage us from having people to our farms. They're just things that we need to navigate around, that we need to make sure that we're doing it the right way so that we don't kind of get into these liability situations. So again, I don't want to come across as discouraging anybody. So here's the scenario. People come to my farm, and most of the time they come to my farm, it's one of two ways. And I have a feeling you're probably in a similar situation. They're either coming to my farm to buy animals, or they're coming to my farm in some form of agrotourism. Agrotourism, you know, it's kind of the intersection of tourism and agriculture. It's not a real new thing, but it's, you know, it's newer, I guess, in the farming world. When I use the word, and you hear the word tossed around, agrotourism, it means a whole lot of things. It pretty much means, you know, anything that you're doing on your farm that is a byproduct of the farming environment. So for example, we often have, every year when we have kidding season, we invite the community to come to our farm, and kids come to our farm, and from the 4-H and the FFA and adults and just friends and members of the community, they come and kind of descend on our farm, and the kids are running around, you know, kids as in animal kids are running around, you know, in the pasture and the fields and in the barns, and you know, the human kids come and get to interact with them. We think it's very important. We think it's an important part of education. We think we benefit from it. So that's an example of agrotourism. Hay rides and demonstration days, you know, again, visits from groups like 4-H and FFA, product sales, like milk and meat and other animal products, those would be agrotourism as well. And any kind of education you're doing on your farm where you've invited people to come onto your farm. Essentially, if you've invited people onto your farm that are not part of the day-to-day operation, the farm hands, the other members of your farm that are helping you create the product, if they're coming on for some other reason that benefits your farm, you've got a good chance that it's agrotourism. And again, it's something that is becoming very popular as people become more and more interested and excited about you know, agriculture, especially small ruminants, you know, sheep and goats, that we're going to encounter that. So let's talk about it. Do you think when I invite 25 members of the community to come onto my farm and to visit with the animals and put hands on the animals, that I've opened myself up for some form of liability? And the answer is, well, of course I have. Anytime you've allowed people onto your personal property, there's a degree of liability that you incur as the landowner. And that's not just the farm. Let's begin with kind of the basic. Let's just talk about when anybody comes onto land that you own and something happens, you have potential, that's the key word there, potential liability. So I kind of went through those slides without even going to them. I'll do that from time to time. So in general, in the state of Tennessee, and in most states, property owners, including homeowners, landowners, they incur this kind of liability. And the liability really depends on who is coming onto your farm and for what purpose are they coming onto your farm. So for example, if I have people coming onto my farm as a part of my regular business, we would call those people invitees. That's just the term that we use. And invitees have the highest level of duty of care. I have more obligation to take care of somebody coming onto my farm as part of the regular business of my farm to purchase goats or something along that line that I've invited onto my farm for this commercial purpose. I have the highest level of duty of care for them, highest of the three categories. And so it's not a ridiculous amount of responsibility and duty of care, but there is a high level that I should inspect and keep my property safe. And in that key word there is inspect. I have a obligation to examine my perimeter areas, the areas where they might encounter, to make sure there's nothing dangerous for them to encounter. And I have a duty to either repair or warn them of these potential dangerous areas. So you can imagine on a farm, I mean, it's an inherently dangerous occupation. We all know that. And inviting people for business purposes onto my farm, I have a degree of liability for those people to inspect and keep the area safe and to warn them of any dangers that have not been repaired. So if there's a big sinkhole out in the field, and I'm going out to look at some goats in that field, and I'm bringing somebody who's never been on my property with me out into that field, and let's say they're following behind me on a four-wheeler and I'm on a four-wheeler, and we're heading out into the field. Well, I have a duty to warn them that, hey, there's a sinkhole over here and I've not got it filled in. Be very, very careful and don't come in that area. I have a duty to do that. And if I don't do that, I'm going to incur some liability if there's some injury. So that's an example of an invitee. A licensee, again, we're going to move down from the most amount of duty of care to a second degree, which is a little bit lower. A licensee is somebody who comes onto your property for non-commercial reasons. You've invited them. They have a right to be there. We like to think of social guests. That's kind of the term I always use in my mind to keep it straight. So if we've invited social guests onto our property, into our farm, or into our home, we still have a duty to care, but it's not quite as much. That inspect part's not there anymore. But we still have a duty to make them aware of any danger that's not open or obvious. And the example that we always had to use in law school was, if you have a hole in your floor of your house, and it's clearly right there in the front and you can see it, that's open and obvious. If I try to hide it by taking my area rug and putting over it, where it's no longer open and obvious, therefore I now have a duty to warn these social guests about it. So going back to my sinkhole scenario, if I've got the sinkhole out in the field and I've not bush hogged around it and the grass is growing up all around it and they can't see it, it's not open and obvious, so I have a duty to kind of protect them from these dangerous things that they wouldn't otherwise know about. That's kind of the way to look at it. If I've made it clear and obvious, I've roped off around it, warning, do not go into it, then I've taken my necessary precautions. And the third of the main categories, and we won't spend much time on this, is trespassers. That is somebody who's on your property that's not there for commercial reasons that you've invited, and is not there as a social guest that you've invited. There's somebody who just wandered onto your property for whatever reason. And that could be somebody who just sees your animals and finds them interesting. And we still have a duty to care for trespassers. A lot of times we'll think, well, I don't have a duty to, provide care for somebody who I didn't invite. Well, we actually do. It's a smaller duty of care, but we still cannot intentionally do things that would set them up for harm. So using the scenario of my hole in the floor, I couldn't cover it up with a rug in hopes that if somebody, trespasses, into my house, that they fall into it and are hurt. Or I can't set up some kind of a snare, outside the apple orchard, try to catch somebody who's, stealing my apples off the tree. You can't do something that would intentionally harm somebody for trespassing. So you still have a small degree of duty of care. What does that mean for us as farmers? We'll get into that a little bit more, but you can already begin thinking of my farm is right on a state highway. Everybody who drives by this area knows our farm because of the goats running around out in the field. And they're all colorful and pretty, and the babies are running around and they're all cute. And people are tempted sometimes to stop and maybe come onto the property to look at the animals. So that would be an example of a trespasser. It doesn't have to be somebody who's, has ill intent, but it could be somebody who's just uninvited, in this term, in this definition, just an uninvited guest. And finally, and I think this is important for farms, it's just important in any property, children are special, and they have special considerations. As property owners, even if a child is uninvited, we have a responsibility to make sure that they don't encounter something that would cause them harm. And that's why we all have to have fences around our pools and things of that nature. Children can be enticed to come into things that are interesting, and farms can sometimes be very interesting. So we have a duty to take some precautions to protect them from that. And I know that's a lot of information, but that's our groundwork that we're going to work from. That is the basic general liability that we have in the state of Tennessee. And this is whether you're on a farm or not. Now we're about to carve away a portion that just talks about farms, but this is the general rule in the state of Tennessee for liability. So what is different for farms? Let's see, let me go to my next slide here. There we go. We have an actual law in the state of Tennessee that limits liability even more if you are engaging in agritourism as a farm. Because, again, the state of Tennessee is very favorable to farms and agriculture, we have a statute that under some circumstances, under most circumstances, will protect you from some liability of injury and death. And it says that no agritourism professional shall be liable for injury or death of a participant resulting solely from the inherent risk of agritourism activities. So that's the key there, inherent risk of agritourism. I said it earlier, and we all know it. Farms have an inherent amount of risk to them. And so what this statute is saying, that as long as you meet the provisions of it, that when people come onto your farm for the purpose of agritourism, that they are assuming a degree of risk that's normally associated with the agricultural industry. And we'll talk some examples of that and kind of flesh that out. But that's a big protection for farmers in Tennessee. So when does it not? And I want to kind of focus on this. So the general rule is if it is part of an inherent risk of agritourism activities, you're not going to have the same amount of liability. But what do you have to do to lose that immunity? Well, the statute goes on to say in section B that there are certain acts. And later on, when we talk about things like waivers, we're going to talk about these very exact same things. There are certain things that a reasonable law just isn't going to protect you in. If you are recklessly disregarding the safety of the participants in this agritourism, it's not going to give you the protection. And that makes sense. If you have actual knowledge or reasonably should have known of a dangerous condition on your land and you don't do anything about it, that is going to preclude you from this immunity. If you have staff on your farm and you fail to train them and they improperly act, let's say, for example, you've got a farmhand or a member of your family even, and they're not acting in a reasonable way, well, that's going to take away your protection as well, your immunity from liability. And of course, if you intentionally do something to cause injury, you're not going to be protected. But here's the biggest one, and this is number 5. Number 1 and 5 are probably the biggest areas that we need to think about. If you willfully or wantonly do misconduct, gross negligence, or criminal conduct, again, it's not going to protect you. And that's pretty much a general rule when we come to these kind of waivers of liability. And this is a statutory waiver of liability, is you have to act reasonably. And if you're acting reasonably on your farm, then you're going to get reasonable protection for liabilities. And that seems fair. And I think the law is very fair, and we're lucky and fortunate in the state of Tennessee to have such a law that allows that. So as long as you're not recklessly disregarding safety of the participants or acting in some kind of a willful or wanton misconduct or gross negligence on your part, or doing something that's criminal, then you're going to have these protections for liabilities. So it makes us feel more comfortable when we want to engage in activities that include people coming onto our farms, that there is an avenue for us to know what to do. And if we do that, we're going to have protections, much more protection than if we were not engaging in this kind of common sense, reasonable activities. So that's the agritourism. There's one more condition that you have to follow. And it's one of those things where it's just a stickler, because if you don't do this, even if you're acting very reasonably and you've taken reasonable precautions, this agritourism protection will not affect you if you do not post a warning sign at your premises in a location where everyone can see it, warning that this is agritourism and that there are inherent risks, and that those risks are on the person who's participating, not on you. So there is an actual very specific language. You can't make it up yourself. You can't just say, well, this is kind of what Brett said, so I'm going to write it on a board and that's going to be good enough. I'm going to post it somewhere. the statute gave the exact language you have to use in your sign. And if you post that sign up, then it's going to give notice to anybody who's coming onto your property, where the liability and risk lies, and then you're going to have these protections. Also, you need to make sure that you are entering the same information in any kind of a contract that where you're having professionals come and doing professional services. If you're, and maybe you're fancier than us, we might put a pot of chili on, but maybe you're catering some kind of an agricultural or agritourism event, and you're having people come on for catering. This would need to be included in that kind of a service contract. So it's important that it's included in your contracts and that the warning notice is written on a sign and is visible for people to see. We'll put it right on the entrance into our barn, because that's usually where the activities are at, and also on the fence posts as you're entering into the property. 2 different locations. It doesn't say you have to do 2, but that made sense to us that no matter where you're going on our property, you'll see it when you come onto the property, and you're definitely going to see it as you're getting out of your vehicles in our parking area and walking into the barn. And this is what the sign looks like. That's it right there. And it gives the exact verbiage that you have to have. It gives the Tennessee Code annotated. And if that sign is posted and you're including that in your contracts, then you've, again, taken that first step. Now it's up to you to act reasonable and to do those reasonable things to not put people at risk. So that is a law that greatly benefits us and kind of takes a lot of the burden off of our shoulders as we're inviting the public to come onto our property to engage with us in these farming activities. So that's it in a nutshell. I want to leave that up there just for a few minutes so that you could have a chance to look at it. But again, you can do a real quick search, and I'm sure you'll have access to these materials and to be able to have the exact signage. And this is the same language that you would need to include in the contracts. All right, so let's talk about a scenario. I'm always a hands-on person. I learn more from scenarios than I do, and usually this is the fun part where I'm talking with the audience and we're getting feedback and such. But you're just going to have to take my feedback, I guess. Scenario 1. I've invited the community to come out to the farm to see the most recent lambs and kids. We have cleared out the barn and provided places for people to sit and play with the newest additions to our farm. I hope by doing this that I'm going to raise awareness about my farm and the animals we sell. You see, I've set up the scenario for agritourism. I'm inviting the public, but I'm doing it for the purpose of benefiting my farm. While visiting the farm with his parents, little Johnny, we all know little Johnny, pulls the hair on a goat and it headbutts him, causing him to fall backwards and hurting his arm as he lands. Would I be liable for little Johnny's injuries? I don't know. I can only see a couple of people's videos and stuff on there, but what do you think? Thumbs up, thumbs down, thumbs up. You think I'm liable or you think I'm not liable? You think I'm liable? Okay. Anybody think I'm not liable? Okay, well, let's take a look at this. In a normal scenario, let's say I don't have my sign posted. I'm not in agritourism. I'm just inviting people onto my farm, or I'm just inviting people to my house. The answer is clearly yes, I'd be liable because he's a child and there's this, I should have known of the risk of this goat headbutting. However, in this scenario, I believe, and again, we're talking about the law. It's nothing but gray area. There is no black and white in the law. If there wasn't, there'd just be one attorney in the state of Tennessee, and he'd just tell us what the law was, and we go on about our day. And I guess I get to farm all the time instead of being an attorney. But I think it's likely in this scenario that it is an inherent risk associated with my particular agritourism. I'm inviting these people, and they know they're coming to put hands on with these goats, that a goat might actually butt one of them, especially since his independent actions, and you go back to the sign, we go back to the sign, his independent actions were done in a negligent manner. So even as a participant, his parents should have, they have some duty there. So I'll go back to this. I think I would find some protection in the law. However, this would be dependent on if I properly displayed my warning information from the statute. If I had not, I don't have a recourse. But I believe, at least in this scenario, that this would assist me in mounting a proper defense for this kind of one. He was acting in a negligent manner. His parents should have supervised better. They knew that when they brought him onto here. We placed that liability onto them because of this agritourism effect. And, it wasn't a danger that was uncommon in my particular agritourism. So that's kind of the scenarios that we encounter. Again, it's never black and white, but that's how this statute would make a difference between absolutely to maybe not because of it. Okay, let's go to a second scenario. Again, I've invited the community to come out to my farm to see the most recent Lands and Kids. We've cleared out the barn and provide a place for people to sit and play, see the newest additions of our farm. I hope by doing this, I'll raise awareness. Again, I've set up all the criteria. This is agritourism. While visiting the farm with his parents, here's little Johnny again. Little Johnny climbs into the tractor I use to clean out the barn. He turns the key and starts the tractor and promptly running into a tree, causing injury to himself. Now, would I be liable or not liable for little Johnny's injuries? Anybody? Yeah, Thomas is saying I'm liable. I agree. Thomas, you're absolutely right. In this scenario, I think I'm liable because leaving the key in the ignition of a tractor when I know I've invited children onto my premises is probably a reckless disregard for their safety. I believe that many courts would determine that knowing that I was inviting children, that leaving a key in a tractor sitting right beside the barn where they were going to be at is probably a reckless disregard for the safety of the participants. And as such, I would find myself exempt from the liability protection. And further, the court would find that the tractor was an enticing thing for a little Johnny as a child. Again, we have extra, duties. I had a duty to protect him from that. And it was a simple fix. All I had to do was take the key out of the ignition or maybe lock the door if it's a cab tractor. But taking the key out of the ignition. So I probably have crossed the line. Again, it's not like the worst thing in the world example, but it's just to the other side of the line of scenario number one. And I believe in this example, this is something that is more on the line of, yeah, I probably got some liabilities here. It probably would have been reasonable for me to have removed the key from the tractor. Maybe I normally keep it in the tractor, but on this circumstance, when you invite people onto your property, you have to take some reasonable precautions to protect them from that danger because they're, again, not a normal participant. So I think in this scenario, little Johnny injuries are probably going to be on me and my insurance company. So I hope we see a little bit of differences in there. And again, the whole point of us kind of talking about this is for us to navigate the best path, not to kind of throw up our hands and say, well, I'm just not going to let anybody come onto my farm. Well, I mean, if you don't want to, that's fine. I can understand that. But if you want to participate in this, there is a reasonable avenue to allow you to do it and to have some protections. But you do have to take some precautions. It can't be farm day as normal. You have to take some reasonable precautions. Okay, take a second here. I'm going to drink my water and keep my my voice going. This is another topic that I get a lot of conversations with. And this, unlike the first topic, this is something that bleeds over into criminal practice of law as well. We were previously, when we talk about people coming onto your property, we were just talking about civil liability. The ability for somebody to sue you is civil. Criminal is when it crosses into, now I could be put in jail or some other liberties removed from me. So when we talk about liabilities of animals, and you're going to find out as we get in, a little sneak peek here, there's both civil and criminal liability, depending on what happens with your animals. So let's talk about that. And again, this is, again, a very common topic for me. I think most of us, I think most people, at least over 50%, have animals, have dogs with their animals, with their sheep, with their goats. I know I do. I have large guardian dogs, LGDs, that I keep with my animals in order to protect from coyotes and stray dogs and other things that might hurt especially my younger kids. So we keep dogs with our animals. But the dogs aren't the only, they're just the most common. My animals themselves can accrue some level of liability based on their actions when they get free and they run through the neighbor's yard and cause damage. So let's talk about that a little bit. Let's talk about liabilities of animals that I own. So strict liability or the one bite rule. When it comes to, I know I get excited talking about dog bites, when it comes to dog bites, guardian dogs and dog bites, there are two basic standards in the United States. Strict liability, some believe you have strict liability, and others believe in what we call the one bite rule. Strict liability means you're strictly liable for any damages caused by your dog outside of a proper defense. So in other words, you're liable unless there's one of these, enumerated defenses. You start off almost on the position of liable. And these defenses are very narrow. So for the most part, you're liable for any injuries that your dog causes. In the jurisdictions that do the one bite rule, and that's a slang term, I'm using the one bite rule because it's easier to remember, that when a person is injured from a dog, the first thing that must be shown is that the dog owner knew or should have reasonably known that the dog would act aggressively in order to hold the owner liable. There has to be what we refer to as a propensity to violence, a propensity to be aggressive. In other words, you have to have good reason to know that your dog, that individual dog, not a breed, that individual dog has acted aggressively in the past or will act aggressively. And the number one way of knowing that is your dog has bit somebody before. And so it's kind of like first bite's free. Some people will say that, one bite rule. So if your dog has bit somebody, well, you're on notice. Your dog has the propensity, has the capability to act aggressively. And so the rules are going to be different towards you in these jurisdictions. Also, if you've trained your dog specifically to be aggressive, you don't have to have your dog bite somebody. If you train them to be aggressive, you know that they are aggressive. Therefore, you've also met that. So it's not just the one bite, but that's the most common. So those are the two kind of general areas that we look at in jurisdictions. Some have strict liability, some have one bite rule. And one bite rule is much more generous to the dog owner, where strict liability is much more generous to somebody who's been bitten. So there's reasons to know your laws. So what do we do in the state of Tennessee? We use both. just to make it complicated, we do both. So the answer is, as often as the answer in the law, it depends. Under some circumstances in the state of Tennessee, we use strict liability. And under other circumstances, we say, no, you have to have knowledge that your animal is aggressive. So it's important that we understand that our dog can make us both strictly liable and under this one bite rule, depending on the circumstance. So let's talk about the circumstances. And again, we're talking about civil liability, injuries caused by dogs. If the general rule is that an owner of a dog has a duty to keep that dog under reasonable control at all times and to keep that dog from running at large. A person who breaches that duty is subject to civil liability for any damages suffered by a person who is injured in a public place or lawfully in or on the private property of another. The owner may be held liable regardless of whether the dog has shown any dangerous propensities. In other words, strict liability. So the general rule is in the state of Tennessee, if your dog bites somebody, you are strictly liable for the damage, unless it falls within one of the very few enumerated defenses. However, and this is where it begins kind of easy, strict liability, and then now we're going to throw in these but, if, and circumstances. If a dog causes damage to a person while the person being bit, is on a residential, farm, and that's why I highlighted that because it applies to us, or other non-commercial property, and the dog's owner is the owner of the property or has permission. In other words, my dog is on my farm, my non-commercial property, or it's somebody else's dog, but I gave them permission to bring their dog onto my property. Then the claimant, that's the person who got bit, has to establish that the dog's owner knew or should have known the dog's dangerous propensity. So now we're back to the one bite rule. So how do you differentiate the difference? It's all about the location. You notice, and I'll go back up, on this one, when we're talking about strict liability, it's public place, talking about a public place. And here we're talking about residential, farm, or non-commercial property of the owner of the dog. So if the dog is on the property of its owner and it bites somebody, the person being bit would need to establish that the owner knew of the dog's dangerous propensity in order to establish this civil liability. If, however, the dog bites somebody on public outside of its owner's property, then we're in strict liability territory, and the owner would be strictly liable outside of one of those enumerated defenses. So again, it's very much dependent on the circumstances, but I think we can draw a pretty clear line here that's easy for us to understand. If your dog is on your property, we follow one rule. If it's on public property, it follows another. Now, there are a few exceptions if it's on public property. If it's in a cage and the person is harassing the dog, like let's say I've got my dog in a container in the back of my truck and I'm transporting it and somebody's poking sticks at it, okay? The law allows for an exception there. The law allows for an exception for police and military dogs. The law allows for an exception if the dog is moving, is doing its job of moving animals from one place to the other. So there are some exceptions, but in general, if it's on public property, it's strict liability. And if it's on your property, it falls under this less stringent one bite rule. I know, that's a lot. Okay, so let's do a scenario. Fido's my large guardian dog. He's in the field, he's in my field with 100 goats. And a bicycle rider, again, I told you I live on a state highway. A bicycle rider stops along the road and enters my driveway to see the goats. The goats are out there playing and they're cute, and he needs a break. So he pulls into my driveway and he gets out and he reaches through and he pets one of my little goats. And when he does so, Fido bites his hand, causing serious injury. Okay, horrible situation for everybody. In Tennessee, is this likely to be reviewed under strict liability, or will it be determined based on whether I knew Fido to be particularly vicious? In other words, the one bite rule. What do you think? Let's say strict liability or one bite rule. What do y'all think? I'm seeing some thumbs down. Yes, you're correct. This is one of those classic scenarios where, again, it's all about where is the dog? The dog was in my field on my farm, and this person came onto my property and then made contact with the dog, and the dog bit him. And so we fall under, again, this policy, and that doesn't mean I'm scot-free. It now depends on whether or not I knew this dog to be particularly vicious, or whether or not this dog had a propensity to violence. So there still may be some liability, but we're in the much more agreeable standard as far as the dog owner to be able to look at. So that is correct. Because Fido's on the farm I own, it will likely be a one bite rule example.
Hey, Brett, I want to do something to change this scenario related to a question that Pamela had. If you have a sign posted at your driveway that says "Beware of dogs," does it change this scenario?
It does change the scenario. I don't know that it necessarily helps you though. We're going to remind me, Thomas, do not let me get out of this conversation or these slides without talking about no trespassing signs.
Okay. Well, and I know that I figured you were going to talk about the dog signs and the no trespassing signs and all that stuff.
I've been bragging about Tennessee, right? But sometimes we just get it wrong. And recently, in the last couple of years, our Tennessee Supreme Court has really gotten wrong signs, no trespassing signs in particular, where they say that no trespassing signs are too vague and ambiguous for any reasonable person to understand what they mean. Therefore, they have no legal significance whatsoever. I did a whole half an hour conversation on a live post when this came out. It's the craziest, but that is the law in Tennessee. So there are certain arguments that are going to be made about a sign being posted. But one thing that I will tell you, how it sometimes can cause problems, it does put the person on notice. However, it also admits that you know your dog is vicious. So now, even if you fall under the one bite rule, by posting a sign advertising that you know your dog is aggressive, you've now kind of admitted for the public that even under a one bite rule, you may have some liability, because it could be interpreted, it may not be the case, it could be interpreted that when I put a sign, depending on the wording of the sign, if I say beware of dog, dog may bite, well, I'm telling you that I believe my dog to be of an aggressive nature, and therefore I'm going to probably fail under the one rule of, did I know that my dog was aggressive? So it can somewhat backfire on you, but it does give notice to somebody not to come onto your property and not to engage with the animals. So it's one of those where it might benefit you in that it might keep somebody from coming onto your property. It might keep this bicycle rider from putting his hand through the fence if there's a sign out there. But if he does get bit, then I'm going to have to explain to a court somewhere how I didn't believe my dog was aggressive, yet I have a sign saying, beware of my aggressive dog. So it's one of those circumstances where it can get a little bit dicey. It's not nearly as clear cut as what we would like. We would like to believe if I put a sign on the edge of my property saying no trespassing, that means you are not allowed to come onto my property. I'm revoking your right to do so. And if I have a sign that says beware of dog, that I put the liability onto you and warned you, therefore, if you come onto my property and get bit, well, that's kind of on you. But the law doesn't necessarily follow that, unfortunately. It does serve a purpose. It does warn people. It does maybe change their behavior. We'll talk about that a little bit with liability waivers. It can change somebody's behavior when they have to sign a waiver. It can change somebody's behavior when they see that sign. Maybe they just won't come onto the property, or maybe when they do, they're going to stay away from your dog. But I don't know that I know that it doesn't automatically remove your liability. It could cause problems for you, actually. I hope that answers the question. And yeah, and I'm not able to see if other questions come in, so at any time, just stop me and I'll engage in that.
I will, but that was my thing, because we had talked about that in Ray County,
Yes.
was that if the sign was posted, it could increase your liability. And so when that came up, I just wanted to.
Yeah, it's one of those, you don't think about that. You think I'm doing the right thing here. I'm posting, but it's one of those where, some tricky lawyer, you know how those lawyers are, can actually try to turn that against you and could cause problems. So, the most important thing in these scenarios are that you are taking reasonable precautions to keep them away from people if you think your dogs are aggressive, because there is still, again, we're talking civil liability at this stage. There is that potential. And oftentimes people will say to me, and I get asked this question 10 times a week, can I be sued for X, or can I sue somebody for X? And the answer is always yes. You can always be sued, and you can always sue. Now, ask me if you're going to win. That's a completely different scenario. We live in a litigious society. Can somebody sue you if you have a sign on your property saying "Do not, trespass"? Dogs on duty, and they come on anyway and get bit. Yeah, they can sue you. Now, would they win? That'd be up to a jury. But though there are some legal aspects that would make for an interesting argument there. Okay. So let's talk a little bit. We're going to get in some other, and this I'm just going to touch on briefly. If your dog gets out and hurts other livestock, there are statutes in the Tennessee Code annotated that say if the owner of a dog is liable if livestock is killed, and ignorance of the dog's habit is no defense for that. So if my large guard dogs get loose and they attack somebody's chickens, well, I'm on the hook for some chickens if my dog gets out and does that. And the reverse of that works too. if your neighbors, and we see this a lot, and I think in small ruminants, if the neighbor's dog gets loose, gets into my field and kills one of my goats or my baby goats, then they're going to be liable for the death of the livestock. So we do have laws in effect for that, and you do have the ability to protect your livestock in the state of Tennessee. So, okay, so let's talk about criminal liability for animals running at large. If there's anything worse than being sued for something that your animal did, it's going to jail for something that your animal did. So let's talk about, are there circumstances, and the answer is yes, there are, in which my animal's activities can actually lead to criminal charges against me? And like I said, the answer is yes. Tennessee Code Annotated 448408 says that an owner of a dog commits an offense if that dog goes uncontrolled by the owner upon the premises of another without the consent of the owner of that premises and the other person is authorized to give consent, or any other person authorized to give consent, like a renter. And it goes uncontrolled by the owner upon a highway or a public road or street or any other place open to the public in general. So in other words, if your dog gets loose and is in the public, you not only have that civil liability with that very harsh standard of strict liability, you also have the potential for criminal liability under the Tennessee Code Annotated to be charged criminally. You probably are asking the question, well, does this really ever happen? All the time. I'm a criminal defense attorney. Used to be a prosecutor for the state. Now I'm a criminal defense attorney. And I can tell you, I have represented dozens and dozens of people on this very statute for a dog running at large. That's what we call it. And it can be animal running at large. Your cow can run at large too, but we primarily talk about dogs on the criminal side. So if your dog runs loose, and notice I didn't say causes injury, serious injury, death. If it just runs at large, you can be criminally held liable. Now, the range of punishments go up depending on what the dog does. If it does nothing, it's down here. If it causes property damage, it goes up a little bit. If it causes serious bodily injury, it goes up. If it causes death, it goes up. So it can go from something relatively minor, but it's still a criminal charge, all the way up to something very, very serious. So for example, it's a Class C misdemeanor in the state of Tennessee if a dog running at large does not cause property damage. In other words, the dog's just running at large. And actually on this particular one, it's a Class C misdemeanor. And I can't tell you the number of times it gets misquoted. In this particular one, there's a very specific line in the statute that says a $50 fine is what the punishment can be. This one does not take you to jail. You can not be sent to jail, and I've had to argue this in many a hearing, and that's what the statute said. So it's pretty easy win. But if it's a C misdemeanor, if no property was damaged, no injury, no death, but you can still get a Class C misdemeanor conviction and a $50 fine. However, the moment you get up to where damage is done to a property, now it's an A misdemeanor. And that's punishable by up to, in the state of Tennessee, Class A misdemeanor is punishable by up to 11 months and 29 days in jail. That's just short of a year, and a pretty hefty fine. If, however, the dog causes bodily injury to another, now we're talking about a Class E felony. We're talking about 1 to 2 years, potential punishment in jail, that's prison time. And we're talking about a felony, possible felony conviction. Now, it doesn't happen very often unless it's really serious. But a felony conviction removes your right to vote, removes your right to possess firearms, removes your right to run for office. You're now a felon, all those things. And then if the injury to the person is serious bodily injury, you're talking about a D felony, all the way up to a C felony if there's death involved. So there are from minor criminal charges, if there is such a thing. If I had any criminal charge, I would consider it major. So there are serious legal ramifications in the criminal courts as well for your dogs running at large, depending on what they do. Causing property damage, to causing injuries, to causing serious bodily injury, and there's a legal standard for what is serious bodily injury. Things that disfigure, things that cause permanent loss of something, broken bones, things of that nature are serious bodily injuries. and all the way up to a Class C felony if it involves death. So there are lots of reasons, both civilly and criminally, for us to make sure that our dogs are not running off of our property. And the laws in Tennessee support us in that. If you keep the dogs on your property, you've got the benefit of this one bite rule. If they get off the property, you're in strict liability primarily. If they get off the property, you also may open yourself up to criminal liability as well. So there's a lot of incentives in the state of Tennessee for us to maintain our animals onto our premises and to take reasonable precautions. There is a defense that if you've taken reasonable precautions to keep your animal contained, whether it's a goat, a sheep, or a dog, that you'll have a defense. So if my fence is up and I got 4x4 woven wire and a strand of barbed wire across the top, and I regularly check my fence, it's kept in good shape, I lock the gates, I have taken all these precautions, and something happens, maybe a storm comes in and a tree falls over my fence, and then an animal gets out, you're going to have some defense there to you, where you might be responsible for some damages, but you're going to have a defense for a lot of this other stuff because you took reasonable precautions to contain the animal. However, if I've got 1.5 strands of high tensile and there's been a tree over my fence for 3 weeks, and the animals just run everywhere on a regular basis, and I know it and I just don't do anything about it, I'm not going to have that defense there. So again, the state of Tennessee gives us some protections if we're acting reasonably and professionally with containing our animals. All right, let's talk about scenario 2. Fido, my large guardian dog, he's still in my field with my 100 goats, same bicycle rider. This time he stops along the road to get a drink of water from their water bottle. Fido goes under his usual spot in the fence and bites the rider's hand, causing serious injury. I think Fido must be upset because he doesn't like bottled water or something. But he goes under the fence, bites the bike rider, causing serious injury. In Tennessee, again, is this likely to be reviewed under strict liability, or am I going to be under the one bite rule? Strict liability, one bite rule. What do y'all think? Think about that for a few minutes. Yeah, this is not going to be as good of a situation as the last time. This rider stayed in the public. He never left the highway, which is open to the public. My animal got loose and bit him on public property. So I'm probably going to be under, well, no, I will be under that strict liability standard. And because Fido went under his usual spot in the fence, that implies that he's done this a lot. Like he gets out anytime he wants to and bites anybody who happens to be drinking bottled water. And so I'm probably going to not have the benefit of the defense that I took reasonable precautions to protect or to keep this animal contained. And so I'm going to find myself in a situation where I'm not only civilly have to have that strict liability standard, and I'm under this scenario, I wouldn't meet any of the defenses, so I'm going to be liable for any damages financially and civilly. But I'm also probably, now I'm going to face criminal prosecution potentially if the DA's office brought the charges. I would meet the standard for that. And this would be one of those felony offenses because I said in the example that it caused serious injury. So because it caused serious injury, we're looking at a D felony, potential punishment of 2 to 4 years in prison because, again, he escaped under the usual spots. I did nothing to stop him from being able to get out, and he bit this person. So I have all kinds of liability in this scenario. I have all kinds of civil liability, potential criminal liability. So it's a bad situation on Tennessee Kiko Farm because I'm going to have to do a lot of explaining for what Fido did in this circumstances. So while I was protected in the first scenario, I'm not going to be protected in the second scenario. I'm going to find myself in some liability issues. Okay. And that kind of, gets us through animals running at large, animals getting out. When do I have some protections? Under what standard do I kind of have some liability? Again, on your farm, you're going to have this more relaxed standard. It's going to help you a little bit. Off of your farm, you're going to be in that strict liability area. And if my goats run loose, they're the same thing. If I did not take reasonable precautions for the fencing and such, and they cause damage to the neighbor's yard, I'm going to be civilly responsible for the damage to what it takes to repair the damage that they caused. So there's all kinds of, scenarios here we can play through. What if the bike rider was taunting the dogs, or what if the bike rider was hurting one of the animals? Those would all introduce certain defenses. But under the scenario that I just gave here in scenario number 2, I think we're in some trouble. Okay, so we'll move from there, talking about animals on our premises and our farms. So I think, again, we're seeing reasonable precautions and reasonable actions give you some reasonable protections. But if we're not being diligent about those, then we're going to incur a little bit more liability. You're seeing a reoccurring theme here on that. The other question I get, and actually this has come up more often lately on social media, I've been asked a few different times, individuals contacting me, whether or not what kind of legal considerations for small ruminant farms do we need to have when it comes to our agreements, whether it's a contract agreement or a sales agreement or a purchase agreement. What kind of guidance do we get from the Tennessee law on contracts and agreements? Typically, the question revolves around, when does it need to be in writing? Sometimes there'll be a very specific question on the actual writing. But in general, what I usually get asked is, when does it need to be in writing? Does it always have to be in writing? Does it never have to be in writing? What happened to the day when I could just, shake another person's hand and my word was good and their word was good and everything would, be upheld? Well, I hope our words are still good, and I think in our industry it is. But as far as the legal standard, again, we got some gray area here. Okay, so let's begin with the base answer. Verbal contracts are legal in Tennessee as long as they do not violate the statutes of frauds or the UCC laws that require some types of contracts to be in writing. So in other words, verbal contracts and agreements are legal in Tennessee. They may not be best practice, okay, but they are legal and therefore binding and enforceable in Tennessee unless there is a UCC issue. I'm not even going to get into UCC issues today. We don't even want to talk about the UCC issues. But what we will talk about is if it violates what's referred to as the statute of frauds. Statutes of frauds is we'll talk about it in more detail. So it is the exception to the rule that a verbal contract is binding. So sometimes a verbal contract is binding. Hard to prove unless you have witnesses, but it can be binding in the state of Tennessee unless it falls under the statute of fraud. So let's talk about the statute of fraud. What falls within that, therefore requiring that to be in writing with a signature? Tennessee statute of frauds, and by the way, most states have this, and there's federal statutes of fraud as well, requires that several types of contracts to be memorialized in writing and signed in order to be enforceable. So if they're not signed and written, they're not enforceable in the state of Tennessee. They're not legally enforceable in the state of Tennessee. The three most important, there are some other types, but the three most important and what we'll talk about include contracts for the sale of land or leases longer than 1 year. So if you have a contract for the sale of land or a lease longer than a year, then it has to be in writing according to the statute of frauds. Does that mean that what happens if you don't have it in writing? It just means it's not going to be legally enforceable, the provisions of it. There's no penalty. You're not going to jail because you had a verbal agreement on land. It's just not going to be legally enforceable, and it's not best practice for sure. Any agreement to pay somebody else's debt has to be in writing, and common sense stuff. I mean, that doesn't necessarily apply to our farms so much as the first one does and the second one, but that is one of the primary areas. If I'm agreeing that, you owe John $1,000, and I say, you know what, I'm going to go pay John for you. I'm going to go pay that $1,000. You can't legally hold me to that because I verbally said it. I have to have said that in writing. That has to be in writing and signed before you can legally enforce me or make me do what I said I'm going to do. And we kind of understand why we do that. Any contract, and this is the one that gets a little bit tricky, and it's one of those where the words are almost counterintuitive. Contracts that cannot possibly be performed within 1 year. The better way of understanding that based upon court interpretation and precedents that we have in courts is that if there's any way that this agreement can go more than a year, it has to be in writing. That's the easiest way to remember. If it is possible for this to go more than a year, then it has to be in writing. Even if it doesn't go more than a year, if it's possible that it go more than a year, it has to be in writing. So those are the main areas that the statutes of fraud says you have to have this in writing. It has to be signed, or else we're not going to allow you any recourse to enforce it. Okay. So, and this is, again, the conversations I normally have. And these are kind of my quotes from this. You can trust me at my word, so much so that I'll put it in writing. I say that all the time. I advise people to put things into writing. I'm an attorney because I see the worst case scenarios. Nobody comes to me when everything works out great. They come to me when there's been a problem. And now they misunderstand or somebody else misunderstands an agreement and it's not in writing. And now we've got hurt feelings and we've got hard feelings towards each other and somebody's wanting to sue somebody else. So I always tell everybody, I put things in writing, not because I don't trust you or my word is no good. I put it in writing because my word is good. So much so that I'll put it in writing so that there's never any question of what I've agreed to do. And a written agreement is the best way to preserve your reputation and ensure that both sides understand the situation the same way. I cannot tell you the number of times where I've sat down, whether it be a business formation, kind of documents or a contract, where I draft up the agreement for two parties and they sit down and read it. And one of them says, that's not how I understood it. And then the other one says, well, yeah, that's how I meant it. And that is the time to flesh out those differences before the agreement goes into effect. That could have easily been a problem where, maybe one person thinks one thing, the other thinks another. They could have went on their way. And then the next thing you know, one's accusing the other of not being honest. So a written agreement really preserves those relationships and reputations in our businesses. And that's why, again, I encourage it, not because I don't trust people, but because I value the relationships I have, especially with friends and other farms and neighbors, family members. I want it in writing. My memory is not so perfect that I can't misunderstand or misremember a detail. And I don't want that to ever be the situation where I think somebody is doing something wrong because of it. So as best practice, I recommend it. For the law, there are some circumstances where it's required. And so that's the kind of gist of agreements, sales agreements, and things that have to be in writing. But the statutes of frauds can be a little bit confusing, and I understand that. Dealing with lands and leases is pretty straightforward. But when you're dealing with these other things that might go for more than a year, you really have to kind of think it through. When in doubt, write it out. That's, again, that's what I recommend. That's what the law favors, written agreements. So let's talk about a scenario. I want to lease the field next to my farm as an additional field for my sheep. I've known the owner for many years, and the owner has agreed to let me use it for the next 6 months until the spring planting is ready for $200. We shake hands and I turn loose my sheep. Is this a good agreement? What do you think? Is this a good agreement? Well, it's not the best agreement, because the best agreement would be you put it in writing. All kinds of circumstances in which people could get hurt feelings. Well, I put money into it with the fencing and I thought you were going to reimburse me, or I didn't know you were going to allow other people to access it for hunting. There's all kinds of reasons you'd put this in writing, but is it a legally enforceable agreement? What do you think? Yay? Yeah, and in this circumstance, it's a lease for less than a year. You could probably get away with it. It's the only this is the only scenario. If I change this to 12 months or 13 months, it would have to be under the statutes of fraud in writing. But If it's a 6-month lease, you could legally still enforce it, but again, it'd be one word versus the other. So again, land transactions for purchasing of land or leases for more than a year. That's the key on there. Okay. Scenario number 2. I've sold 5 goats to a farm in Kentucky. The agreement includes a provision that if the new owner were to ever sell the goats, I would have a right of first refusal. That is, they would have to give me the right to buy that goat back before they offered it to anybody else. And I'd have to pay whatever, you know, the reasonable rate was that other people are willing to pay. But that's what a right of first refusal is. I probably should have explained that in the slide. So that's what we've agreed to. Hey, I really love these goats, but if you ever sell them, sell them back to me, and we agree, we shake on it. I write up a receipt for the payment, a bill of sale that, I've sold you these 5 goats for X price, and you paid me on, this day, and you're paid in full. Is this a legally enforceable agreement? This is a little bit more complicated. What do you all think? Think about it for a minute. Do you think this is a legally enforceable agreement? And the answer on this one is partially. On this one, part of this agreement is good, and the courts will split the baby on contracts and agreements. They will enforce part and not enforce part if certain parts are found to be illegal or unenforceable. The actual sale is good. You've got a bill of sale. You didn't have that really isn't the writing that we're talking about. I kind of threw that in as a red herring. But you don't have to, if I'm selling a goat, it doesn't have to be an agreement in writing. There's no requirement. It doesn't fall within the statutes of fraud. Best practice says that you do, but you don't have to. It's still going to be enforceable. However, when it comes to the part about the right of first refusal, that is a condition that could go on, a condition of the agreement that could go on for more than a year. Think about the scenario. 18 months later, he decides to sell the goats. Would he have to honor the right of first refusal on this verbal agreement? And the answer is it would not legally be enforceable because, again, this is a condition of the agreement that could go for more than a year. Therefore, it has to be in writing. And the reason that we have these statutes of fraud and certain things have to be in writing is when it's very, very important, like dealing with land, or if there's a period of time that elapses, we understand and the courts understand that you're more likely to not remember all the details. Therefore, they want it in writing. So because we didn't put a time limit on this right of first refusal. I didn't say right of first refusal in the first 11 months. It is a provision of the contract that could go more than a year. Therefore, that provision, in order to be legally enforceable, would have to be in writing. So again, this is why we just write them out. It just makes more sense. So I hope that kind of explains that a little bit. Best practice, I'm going to tell you, is always write it out, especially among friends and people that you know. Those relationships are too important to put at risk because of a misunderstanding or a misremembering years down the road. So I always advise people, please put them into writing. It doesn't take that much to put into writing. But there are certain provisions that you have to in order to be legally enforceable. And I don't know, time-wise where we are, but
can we? Well, I was going to say because I've got several questions here that we want to get covered.
That was my last slide, so I was about to say, well, my very next slide was questions. So there we go.
Okay. So let's. I'm going to back up, Jesse. Is it okay if I go ahead and go through these with him real quick?
Yeah, that's fine. We've got Linda and Amanda too, so.
Yep, and that's why I'm going to just try to cut these off real quick.
Okay.
So a couple of the questions. One was related to putting up signs about livestock guardian dogs working. And I've seen some of those signs myself. And so I
like those signs. I like those signs because I do believe, again, they change behaviors and it might prevent an injury. That's why I like it.
Okay. And yeah, so a couple of folks had said something about LGDs at work, that sort of thing. And what kind of wording do they need to state? Anything that will work with Tennessee laws? Is there some type of a verbiage that will work with Tennessee laws?
There's not, unlike the other statute that gave us the exact verbiage, the signs just need to simply reflect the condition, which is, for me, for example, it would be, large guardian dogs at work, please do not approach the dogs to pet them. I would just kind of give instructions for people who, there's a lot of people who, they're never around working animals. They don't understand that these dogs have never lived in a house. There's dogs out in my field that don't want me to pet them or come up. They'll go the other distance. So just to kind of warn people of the circumstances and not to assume that they understand when I say working dog, what that means. Working dog means, don't approach them, don't interact with them socially. They're here performing an important function on my farm.
Okay. Someone asked about, you were talking about the Class C misdemeanor of what if a neighbor's dog keeps coming to my property and an owner will not keep them up even when I go ask them to keep them up.
Mm-hmm.
Yeah, what's their?
Well,
yeah.
The liability, both civilly and potentially criminally, is on the dog owner. If the animal comes onto your property and injures or kills your livestock, they would be civilly liable for any damages. And potentially, there's the potential that they could find themselves in having, again, a criminal charge, depending on if the animal does damage to the property or doesn't do damage. It'd be either a C or a B misdemeanor. What I would do if I've talked with my neighbors, and of course that'd always be my first step, is I would then begin having a conversation with my sheriff's department or local law enforcement so that they understand the circumstances and they understand the situation. I know in the county that I work in, that law enforcement would be very open to then going and talking with the owners themselves and saying, look, you've got some liability here if your dogs get loose again. I'm giving you a warning. Any other opportunities that those animals get out and roam free, you're not going to be able to say you didn't know about it because I'm giving you the warning and I'm writing a report about it. So that relationship with law enforcement often helps out a lot in that scenario.
Good. Okay. Next thing, and I'm going to throw in two scenarios here really quick because at some point people are going to think about them. You've got a livestock guardian dog out there and somebody else's dog comes into the field and they do their job. What's your liability for that person's dog?
You would not have, under the laws of Tennessee, in that scenario, I do not believe you'd have liability. You have a right to protect your animals, whether that's you directly protecting your animals or your animals protecting your animals. When that dog comes into that field, that animal in its intent to either do harm or is where it doesn't belong, your dogs protecting the herd are going to have some protections for liability. So under most circumstances in that, you're not going to have any civil liabilities. If that dog comes onto your property, you've not done anything that would lure that dog onto your property. There's some caveats that you have to play, but in general, you would not have liability for that.
And another one that I personally had to deal with, dog was on our place, attacked an animal. I shot the dog and the dog made it back across the fence to the other person's place. Yeah. What's the situation there?
Again, there is statutes in the state of Tennessee that I'm going to flip through here real fast that say that right here, Tennessee Code Annotated in Title 44, Chapter 17, Part 2, that no damages are recoverable for killing or injuring such a dog that has come onto your property and is either attempting to injure, has injured, or has killed livestock. So that's how the state of Tennessee law reads.
Good, thank you. Let's see. If you are renting animals in a contract land clearing scenario, what do you need to do to cover liability for someone else entering the pen where your animals are or being injured by LGDs in that situation?
Okay, make sure I understand the scenario. So you're renting property.
No, you are in a land clearing contract.
Oh, okay. So in that scenario, again, the language of Tennessee statute, when we talk about what liabilities you have for animals, and I'm pulling it right back up here, This is where we talk about a dog that is on a resident farm or non-commercial of the dog's owner, but right after that it says, or is on the property by permission of the owner or as a lawful tenant or leasee. This is a circumstance where the dog would be on the property by permission of the owner of the property. So because you have permission to be there and that dog is there performing that function, you would have the same protections, or I guess you'd have the same obstacles to go through for liability. That is the propensity for danger, be dangerous, that if it was on your own property.
Okay, and that would be for the goats or sheep as well. If somebody went on to the property where your goats or sheep were and they were injured by a buck.
That's correct.
Okay.
Because the question really comes down to, is your animal there legally? And the animal can only be there legally in two different ways: one, by invitation, and two, because you own it. So as long as you're in one of those two scenarios, then you're under the same umbrella statute.
Okay. The next thing, if an animal gets out and causes a traffic accident, what's the scenario there?
That would be an animal running at large in a public space, and therefore you'd be strictly liable for the damages that it causes. And again, there's always scenarios, but you're going to begin at the point of being strictly liable. If my goat runs out into the middle of the highway, somebody slams on their brakes and runs off the road and does damage to their vehicle, I'm gonna be strictly liable for the damages that animal caused.
Okay.
And again, there's always defenses such as, I took every reasonable precaution and the animal got out, and so there's always those defenses there. But the point where we begin at is strict liability and me being liable, and then the burden's on me then to prove one of those defenses.
Okay. In what scenario is a signed, handwritten, typed agreement sufficient versus a more formal, notarized agreement?
In almost every scenario, there are a couple scenarios of things that have to be notarized or witnessed, and that's all a notary is. A notary is essentially a professional witness, somebody who can later attest to the court, somebody who's not part of the agreement, that yes, I watched them sign it and nobody was under duress, and yes, it was this person who signed it. That's what the notary is really doing. They're attesting to the signature that this was really the person. I made them, I either knew them or I made them show ID. That's what notaries have to do. And so I can attest that that is their signature and they were not under any kind of duress when they signed this. So there are some examples of that, but almost every example of what we're going to be dealing with, sales agreements, things of that nature, outside of like a traditional land buying, which of course you want to do the right things on that. But like a siring agreement or, agreement for buying and selling, sharing of an animal, those would just be in writing and require a signature. It doesn't have to necessarily be witnessed. Again, why would you want to witness? So that way you have a third party if ever there were questions. But in general, I don't have witnesses on most of my contracts unless it's a really big contract or if it's a contract with people I don't know.
Okay. Any suggestions for wording a waiver for farm visitors?
Yeah, waivers are, some people disfavor waivers, and a lot of attorneys disfavor waivers. I like waivers. I think waivers are good. I think they serve a purpose. That's one of those where I'd have to sit and talk with you specifically, because what you want to include in the waiver are what activities are being conducted and what is being waived. There are certain things that can never be waived, regardless of what you're doing, and there's certain things that can be. You can never waive intentional harm or reckless or gross negligence. So you can never waive that away. You can't have a document that says, no matter what happens on this farm, I'm not liable. Well, no, that's not going to be legally enforceable. So you don't want to go too far with your liabilities because the courts aren't going to let you waive away all your liabilities for intentional conduct or gross negligence. But a waiver that follows very similar to what we saw with the agritourism guidelines that talks about, that there are inherent risks, with this activity, that you're assuming those inherent risks when you come onto this farm, that you understand that, and that you waive liability on those inherent risks. Those are the kind of things that I would normally include. But I'd also want to specifically talk with people about, for example, what kind of farm, what kind of landscaping. I mean, are we talking about, ponds? And that way I can include those into the waiver if they were very specific. So it is something that you do kind of want to talk with your extension agents, your insurance agents, attorneys. There are a lot of people who can give you good advice on waivers. But for me, again, the one important aspect of the waiver is that it changes behavior. When I have to sign a waiver, I am now likely to be more cautious with what I do when I'm on your farm, because I understand that there is this inherent risk, and I've just put the responsibility onto myself for some of that. And so I do believe it changes behavior, and I think it has a great value for that as well as the liability.
Thank you. Next question is, so let's say that, is there a procedure you would recommend to follow after killing a dog in the act of harming or killing my animals? Contact sheriff department for a report. Is it best to let local Leo contact the dog owner? Never happened, but it's stuff I consider. So yes. What do you do? Let's say you shoot the dog, killing your animals. What do you do?
The proper thing to do is to notify. And who you notify depends upon your relationship. If it's my neighbors, they're going to hear it and take it better coming from me if I've got a good relationship with them. If it's my good neighbors and people who I trust and consider almost family, of course, I'm going to go over and say, hey, I'm sorry, your dog got out. It was killing one of my goats. I had to shoot it. And I'm sorry that it happened. I didn't take any joy out of it, but that's what happened. And that's just on a relationship level. However, if I don't have a relationship, or maybe I don't even know who the owner is, and then contacting law enforcement and letting them, because they can help de-escalate the situation, explain the circumstances, and sometimes it comes better from them, and they will be aware of it in case anything else is reported. Let's say the neighbor then contacts them and wants to charge you with dog murder or something. They could then explain, I understand the circumstance. I wrote a report on this. This is what happened, and he was within his rights to do so.
A little bit more on that. Do you have to have that report if you plan to try to pursue reimbursement for that animal?
It helps. Sometimes insurance companies will want some kind of a report. If the person refuses to pay or turn it over to their insurance, and you have to go the route of some kind of a lawsuit to get reimbursed, then you definitely would want some kind of a report to memorialize what occurred.
Thank you. What about if you use a guardian donkey and it bites someone who tries to pet it?
Same thing as we were talking about. I mean, it's very similar to what we were talking about with the guardian dogs. It would be under the same rules. If it's on your property, you'd fall under the kind of propensity to know that it's aggressive. I think it would fall under the very same standard. And why was the person on there? Did they have permission? All those same things we talked about with the dogs would apply. And if you got a donkey that has a propensity to be aggressive and it bites everybody that comes around and it's just a cantankerous thing, then you're going to have some moral liability if it harms somebody.
Very good. I didn't think about it that way myself. And the last question I think that I've got here in the chat box is, in my area of Tennessee, most people will not lease land for livestock because they think they will be liable. What is the owner liable for if I am the one leasing the land?
Well, they would not necessarily be liable for the actions of the animal. It's one of those circumstances where you want to clearly define in the lease liability. For example, we haven't talked really about insurance, but I mean, of course, the answer to a lot of liability is insurance on it. If I were leasing land, I might want to put a part in there that, the person who has animals on my property assumes liability for the actions of the animal, and that they're going to carry appropriate insurance that, property insurance that would, cover those. And I think that can easily be covered in a lease agreement. And that's one of those things where it's better to talk about it before it occurs rather than after. you will probably all agree on the front side of it. But after, the dog bites, the butt, headbutt somebody, then all of a sudden everybody wants to be kind of clean hands, and it's a lot harder to get an agreement.
Yeah. There was actually one more thing here, and then I don't know. I want to ask you if you covered something. Do wedding venues and other barn rentals fall under agritourism and the law of protection?
Yes, they sure do. They are very. It's a very good example. Corn mazes, bed and breakfast. They're becoming popular now with farms where people want to come and live on a farm for a weekend, and all of that falls under agritourism. Sure does.
Okay. Did you mention the purple paint law?
No.
I had to take a phone call, and I didn't know if you.
No, I didn't, and I'll briefly cover that. And it's just one of those where I have a lot of. Again, I say we live in a great state but sometimes we lose our minds. And I mentioned briefly the most recent court opinion from the Tennessee Supreme Court, where they said a no trespassing sign that says no trespassing does not have any legal significance because it's too ambiguous and people don't really understand what trespassing means. Of course, I said the only people who don't understand no trespassing was maybe those justices at that moment, because I think we all understood it just fine. However, just a few months, I think it was 3 months after the Supreme Court passed that, just to show you how sometimes disconnected we are and why you often want to get good advice, our legislator in Tennessee, they passed a law that said that if you want to mark no trespassing boundaries, you don't even have to have a sign. You just got to spray paint the tree or post with a purple stripe. So while we have a Supreme Court that says a sign saying no trespassing doesn't have legal significance because it's too vague and ambiguous, we have legislatures in Tennessee passing laws that said, a purple stripe's good enough. We kind of understand what that means. So it is one of those, it's nowhere near as clear cut as we would like it to be. I think we all would like it to be, hey, if I, don't want you on my property, you can't come on my property. But it's nowhere nearly as clear cut as that in the state of Tennessee. I hope we get some guidance on that in the next few years as we have some cases that challenge that.
And thank you, Mr. Knight. I apologize. I told you to go a little longer than what we had scheduled for you tonight. I didn't realize that there was two things scheduled tonight. But if you want to unshare, I think we've got Amanda that's going to come in and talk about FSA. And if you want to stick around, there may be some more questions. And Jesse, you give me some guidance on that. They may be able to answer some of those at the end when we get done.
Yeah, that's fine. Or if you prefer, Brett, maybe Thomas can ask them for you. That way you don't have to hang on to the meeting, whatever you prefer.
Yeah, I can do it.
Okay. Thank you, Brett, so much. Great information. Thank you. All right, Amanda, you want to take it away? Or Linda, whichever one.
Yes, I am sharing the screen to get it to it.
Good evening. I'm Linda Barnes. I'm a senior farm loan officer with the Farm Service Agency in Selmer, Tennessee. The first thing, I know it's been talked about several nights, but tomorrow is the last day to sign up for the Corona Food Assistance Program. We've paid out a lot of money to sheep producers across the state. And in our county, we have not had any wool producers, but if there are wool producers who have suffered a 5% or greater loss during this spring period, be sure to file, because tomorrow is the last day. And we have been told that there is another CFAP program in the works. So you need to get signed up for this one in order to be eligible for the second one, as far as I know. Sheep and goat population is about 10,000 in Tennessee, so I've been told, and it's a good fit for the small or part-time livestock producers. We make loans. Your Farm Service Agency, if you go into there will be the program side, and then there will be the farm loan side. Some offices may not have a farm loan person staff there all the time, but you can ask them and they will make an appointment to meet with them. The loan that best fits sheep and goat producers is the microloan. The microloan is a simple application with less paperwork for loans less than $50,000. Okay, there's one type of microloan, an annual operating loan. That's just for 1 year or can be up for 18 months. And it is an annual operating loan. It can be for a crop. It can be for hay production. It pays for seed, chemical, fertilizer, land rent, anything that is on an annual basis. And it is due back in 1 year, then we can do another one. But an annual operating loan is only for 1 year's production. That loan has to be 150% secured. So whatever loan you're asking for, if you're asking for a $10,000 loan to put in hay, the hay is worth $10,000, and then you would need to put additional security to make the 150%. Another piece of equipment, some livestock, if it is available. If it is available, I'm going to say that. It's supposed to be 150% secure if you have additional security. The micro term operating loan is for the purchase of livestock, brood stock, and equipment. The loan is set up to 7 years, and it has an annual payment unless you want it on a monthly payment. The interest rate is locked in for the life of the loan. The current interest rate is 1.25%. The loan is for livestock. A loan you can apply on the same application to get a piece of equipment and livestock. There can be multiple applications, multiple things that you are wanting to do, and it all be on one application. These 7-year loans can also be used for minor farm improvements, such as walk-in coolers, hay barns, hoop houses, irrigation system, and farmland can also be purchased if it is less than $50,000. The microloan application, you have to have some type of farm experience and or business experience. Or as a first-time applicant, you may be required to get a mentor, someone that will help you and guide you and boost you along, give you the support that you need for your new enterprise. To purchase farmland, you must have had 3 years of farming experience or business experience. Or if you have an ag degree, that would count for 1 year. Or if you were a veteran, that would count for 1 year. But you have to have some type of farming experience if you are going to buy farmland. If you're going to buy livestock or equipment, we can work with a mentor or your FSA person. You don't have to have those 3 years. And this is for I don't know what I was going to say. All of these loans have to be agriculture. They have to be agriculture related. And we don't get into lawnmowers or things like that. It has to be specifically an ag related. Microloans have to be secured if you're buying livestock or equipment at 1-to-1. If you buy $10,000 worth of sheep and goats, they will stand for themselves. If it's an annual operating loan, it needs to be secured 150%. But livestock and equipment, microloan, it goes to 1-to-1. Some of the eligibility requirements are you must be 18, you must be a citizen, you must have acceptable credit, you must not have had any prior Farm Service Agency or Farmers Home Administration write-offs. You must have sufficient managerial experience and be the owner-operator of a family farm. This is not corporate. Microloans are up to $50,000. They are our most popular loan by far. When you apply, there will be a fee for the credit report. There will be a fee to file a financing statement to show that FSA has a lien on whatever you're buying. And there will be a fee for a lien search. But all total, it would probably be less than $50. Those are that's all the fees you'll have for the life of that loan. Another loan, a group of loans that is popular throughout the state are youth loans. And that is for 4-H and FFA members to finance their projects. The 4-H or FFA advisor must write on the application that you are a member in good standing and that they will supervise your project. These are a maximum of $5,000. That can be used annually to put in a crop. I've had a young man that he got a youth loan every year he was in high school, and he put in 30 acres of soybeans. It can be used for show stock. If your children are wanting to show, you can get a youth loan, and then when you sell those, or if you keep them, the loan will be structured according to what your project is. Must be an agricultural project. The interest rate in September is 1.25%. And the length of loan, the length of time is based on what your project is. But you would just need to work with your loan officer on that. Then we skip to a whole other category, and it's just our direct loan programs. And our direct loan programs are the same, annual operating loans, but it goes up to $400,000. Annual operating loans are due in 1 year. Really the same, they must be 150% secured. If your crop is 400,000, then I'm gonna say I'm gonna need 200,000 more of additional security. Livestock and equipment, direct operating loans are up to 7 years, and that's for the purchase of brood stock and or equipment. It would be divided into 7 equal payments. All of this is based on a cash flow, and I use all projected farm income, all of your non-farm income, all of your farm debt, all of your non-farm debt. I put it all together into a cash flow, and we must be positive. Again, all of the direct operating loans are 150% secured. We get a lot of questions about buying farmland. And there is a provision that says you must have 3 years of farming experience. The 3 years, again, can be one of them if you are a veteran, or one of them if you have an agribusiness degree, or if you have filed a Schedule F on your taxes 3 of the last 10 years, or someone can document that you have managed their farming experience. There's different ways, but that's pretty much set in stone that you have to have. Even a beginning farmer has to have 3 years of farming experience. When I'm looking at a loan, the farm income has to be proportionate to the farm loan. You can't come in and ask, well, you can, but I wouldn't approve it. You can't come in and ask for $400,000 to buy a loan and you got 25 goats. That is not proportionate. The farm income has to be proportionate to whatever the farm expense is going to be. There's another loan called the down payment loan, where if you are a beginning farmer, you can put 10% down, and then we finance the rest of it. Another type of loan that's been very popular when you get on up in the larger loans is a participation loan, where I work with a bank or Farm Credit or something like that. They make a loan for 55%. FSA makes a loan for 45%. You have 2 payments, but it allows you to get on up and buy a piece of property that $600,000, $700,000, $800,000, because I can go up to the 400,000, but you still have to meet all the eligibility requirements. Good credit, farm income, everything has to be cash flow. The Farm Service Agency direct loan program and the microloan programs are designed to help farmers start, purchase, or expand their operations. And your FSA person, when you go in and meet with them, your loan officer, everything is tailored to your operation. It is called supervised credit. They will help you develop a farm plan that is specific to your operation. Again, you just need to work with your Farm Service Agency farm loan person, find out who they are, and I think you'll be welcome.
Are there any questions for Miss Linda? Let me check the chat really quick. Do you have any loans for people with credit blemishes?
That's a really good question. There is no specific credit score that you have to have. We look at a history. Have you been continually late? Is the trend that you are always behind? Is it medical payments the reason that your credit is not where it should be? I get questioned to say, what does my credit score have to be? Well, there's not anything specific, but we have to look at a trend and what the reason is. But if it's explainable, then we could probably go forward.
Any other questions for Miss Linda? Where do we go to apply for a micro-term loan for livestock and equipment? So what this is showing right here, this is showing the CFAP program that we've been talking about. But if you go all the way to the bottom, if you're in Tennessee, you would select Tennessee. And so I'm just going to choose my home county is Perry County. And then I would click go. And then right here is my service center. Easy as that. So what you'll notice here is for Perry County, we do not have an FSA office there. Sometimes one office will cover multiple counties. So if you do not have a physical FSA office in your county, it just may mean that one physical location will cover multiple counties. So as you can see in this case, they do cover 3 counties, but you can go to USDA.gov, and then at the top of the USDA.gov page, it says find your local service center. So any other questions about the FSA program? Okay, next I am going to very, very briefly, I know it's already been a long evening, but I'm going to briefly go over the Ag Enhancement Program. Some people do take the Master Producer classes to get 50% cost share for Ag Enhancement. I wish in the early survey, you know, we kind of had talked about how many people had applied for Ag Enhancement and how many haven't. But every year, Tennessee Department of Agriculture puts in almost $22 million towards these Ag Enhancement programs. The enrollment period for this year is October the 1st through the 7th. So here's the website up here, tn.gov, agriculture, TAEP, or all you have to do is just Google TDATAEP, and it pops this page up. And the booklet this year, so they do come out with a paper booklet. I hope y'all are able to see that. This is the 15th year of Ag Enhancement this year, so we're pretty excited about it. It's 36 pages. I'm not going to go over everything. I'm going to focus specifically on what small ruminant producers can apply for. So as you can see here, livestock equipment, you can apply for a reimbursement of $1,800, or the genetics program reimbursement, $1,600, herd health, working facility structures, hay storage, and livestock solutions. So those are all of the different categories that you as a small ruminant producer can apply for. So some of the eligibility requirements: be a citizen of the United States, be at least 18 years or older, be a resident of Tennessee, and also operate a farm in Tennessee. So they're pretty easy. Like I said, this year, some of the application periods, they've actually shortened the application period. It's only open for a week. As long as your application is postmarked October 1st through the 7th, it can't be any earlier or any later than that time frame, then you can apply. But 50% cost share. So after completion of tonight, after completion of the program, you are qualified for 50% reimbursement. I'm going to skip through some of these. So for the genetics program, you see that they do offer it for cattle, but for small ruminants, TAEP, you have to have 50 head, and that can be, bucks, rams, lambs, ewes, kids, does, how many or whatever your maximum number is in that calendar year must total to 50. So within this program, you can purchase, a buck or a ram. Whenever we were talking about reproduction strategies, if you do want to start going towards artificial insemination, they do, help pay for semen from eligible bucks or eligible rams. They do help you pay for those semen tanks, some of the storage, and then also AI fees. Now, some of the requirements, they do have to go through BSC, so they must be, soundness tested, tattooed, microchip, scrapey tag, some type of identification. And then also they must come with registered papers. And then also some have to come genotype tested. Rams have to be clean for scrapey and spider genes. Sheep and goat owners are also eligible for livestock equipment. Same head requirement on this, 50 head within a calendar year. So some things that are sheep and goat specific, if you are in maybe the dairy industry, some of those, milk feeding machines, fitting, fitting stands, if you need some shears, but also things, scales, if you, may have to give medicines, or if you're doing load lot sales, or maybe you're selling off the farm and need to be able to weigh things, get you a set of scales. Also, feeders, hay rings, hay feeders, fly sprayers, The pasture sprayers have been very popular in the past couple of years. And they will also help pay for a GPS to put on your pasture sprayer. So for livestock equipment, the maximum reimbursement is $1,800. But for you completing this program, it's a 50% cost share of $1,800. You can also purchase either, slightly used or used equipment. If you need a tilt table, maybe you need a hoof trimming table, you can purchase those things too. So this list right here, you can purchase either new or used, but they have to still be in excellent working condition. They can't have rust on them. And then you have to purchase them for a reasonable price. So for the working facility structure, this is only for the covering only. This is not for the previous slide, you're handling equipment. This is the cover. Same head requirements again, but on this one, your reimbursement cost share is $2,500. So for this, they will help pay to purchase any new permanent structure that is bolded in there, permanent. It can't be one of these mobile working facilities. It does have to be, a permanent structure. On this, whenever you submit for, reimbursement, in the past, I haven't seen reimbursement paperwork for this year. I know that's not out yet, but, in years past, you had to draw the diagram of your working flow and then also, how much the working facility covered. Here are pictures of that. You can build a stand alone, cover, or if you, crowd your animals in the barn and then flow them through the working facilities or maybe the outside edge of the barn, then they do pay for like a lean-to, an addition to an existing structure. Here's another working facility structure. They will help pay for working pens, but with the working pens, there is a minimum and a maximum size to those. Of course, it does have to be, treated lumber, or it could be metal, pipe fence, or gates. The good thing about whenever you either look online or you get the booklet in your hands, TDA does a great job with, all of these illustrations. I usually keep, 2 or 3 of the booklets laying around just so I can show producers all the time. Because, they have spent time on how animals flow, and they want you to be able to work your animals, productively and safely. So one of the last programs that sheep and goat producers can sign up for is hay storage. Now on this one, it is the same head requirement. So it is the 50 head. Or if you've got hay, now whenever you read this, you do not have to have 50 head of goats or sheep and 50 head of, hay. It's an or. You don't have to have 100 acres if you've got, the 50 head. But on this, there's a minimum size of 900 square foot. One thing we have to pay attention to also is the minimum eave height, and that is of 14 foot for new structures and additions. You'll see on this next page that just like the working facility covers, sometimes we do build permanent lean-tos, permanent side structures. Same goes to this. You can do a lean-to, or you can build a, full barn. One other thing to remember about the hay storage program is that one side must be left completely open. You can only have a maximum of 3 full sides to the barn. We all know that whenever we're baling hay, we must let it rest out in the field. We have to get that moisture content down so that we don't have spontaneous combustion. And that's one of the reasons why you can't have a fully enclosed barn is for safety. You want that airflow in there. So if you're a row cropper, you can apply for that. I'm not going to go over that. The last program that sheep and goat producers can apply for, so this would be for some larger operations. On this one, before it was a 50 head, this one is 150 head. So this is for, if you need some type of feed bin or auger, maybe you need a manure spreader, or here is where if you have multiple farms and you're going to be, moving your handling equipment, this is where you can apply for a mobile working system. I know on one talk we were talking about, silage. If you choose to go feeding the silage route, you can apply for a silage bagger. And then if you go that route, an unloading forage feeder wagon. I know I kind of ran through that really quick. I don't want to keep you guys too late tonight. But you can always, contact your local Tennessee Department of Agriculture representative. They do have livestock health technicians. I had Kathy Moore scheduled, but the AHTs also do animal welfare, and Kathy got called to Tipton County to a horse rescue. So she had to travel all the way down to Tipton County, so she couldn't be with us. But again, do remember there's one big change this year, and that is the application period, October the 1st through the 7th. Not any time before, not any time later. Due to COVID, they're not accepting hand delivered applications. So if you live around the Nashville area, don't go to Hogan Drive and hand deliver it. And then also you can't scan an email, but you can apply online. The majority of the producers that I work with do apply theirs or do apply online. But with that, if you have gone through Ag Enhancement before, you will need your TPN number. If you have never applied for Ag Enhancement before, you will not have a TPN number. I know I was emailed the list of TPN numbers for the state. If anybody needs a TPN number, you may want to contact your local extension agent to get yours if you've lost it, misplaced it. But one good thing about applying for Ag Enhancement online is you get an email. They automatically send you an email with the information that you put in. It also shows exactly what you applied for. If you hand mail it, there's always a question, did they get it? Did they not? If you don't send it registered mail. I see a chat here, 100 acres of hay this year. Is a used tractor or baler included in the 50% purchases? So last year, TDA had the hay equipment program where you could purchase baler, tedder, rake, cutter. What they're going to do is they're going to start alternate years. So last year, they had the hay equipment program, and this year they have the hay storage program. So unfortunately, this year you're not able to purchase hay equipment, but you are able to build a barn. If you have pregnant stock, can those babies be included in the number for eligibility? You have to look at the application, and it does say within that year. I really don't think I've had that question asked, if they're unborn, but I would say that if they're unborn, you could always have risk of an unborn pregnancy. So I would personally not count any hooves or mouths that are not on the ground. I wouldn't include those. And so right now, these hard copy books, your local TDA animal health technicians, they go out across the entire state to deliver these. I know that my local AHT hand delivers some to my office, so you can reach out to your local extension office and go by there and grab a book, or they also drop them off at your local feed supply stores. A lot of your feed supply stores will have them there on the counter whenever you check out. And I see that, this year's book is orange. So you'll be looking for one of those white and orange books. They haven't been delivered to the AHTs yet. Hopefully, us extension agents are crossing our fingers that, maybe we'll have those in our hands by, late next week. But I would call, instead of making a special trip to your local extension office or farm supply store specifically to get the book, I would just call up there. We don't have them in hand yet, but hopefully maybe by the end of next year, or next week, I'm sorry. The last thing that I'll mention is in the chat, it says, do we go ahead and build it or wait to see if we are approved? Your receipts must be dated October 1st or later. So if you were to go out and buy tin and lumber and gravel and crusher run and geotextile tomorrow, no, those purchases will not count. It must be October 1st or later. Now, if it's October 3rd and the farm supply store is having a good sale, or maybe the local, lumber place is having a good sale, and if it's October 3rd, and if you've already sent your application off, you can go ahead and purchase those and build your hay barn, but you still are running that risk, and I'm not going to speak for a TDA and say, well, most of them do get approved. Most of them do get approved. However, there's always glitches in the system. And I just know that if you purchase anything, after October 1st, before you get your reimbursement in the mail, do keep those receipts for reimbursement. Keep all receipts, because you must submit a copy of all of your receipts, pictures of everything, and then we'll email you a copy of your producer certificate, and you'll have to send in a copy of that. Are there any more questions about ag enhancement? All right, I'm not seeing any.